Hello. When you're an innovator pitching for large contracts, there's a good chance that you're going to come across some tender documents at some stage. But let's be honest, many of those tender documents do not spark joy, especially when you turn to the IP clause, the intellectual property rights clause, often buried in the middle of fairly lengthy requests for proposals or invitations to quote. And one innovator here at the PitchMark community has sent in this example of an IP clause to pluck it apart to see what it actually means. And of course, what you can do about it if you find that the intellectual property clause is just too onerous. Our PitchMark legal advisor, Frank Rittman, also joins us for this discussion. Hi, Frank. Great to see you.
Morning, Mark.
Cool. So let's walk through this IP clause together first, and then get your advice as to what we should do with it. It starts off well enough. As you can see, parties agree that background IP is and shall remain the exclusive property of the party owning it. That's easy enough. Background IP is that intellectual property which you bring to the ordinary course of business. It's usually what your business is founded on. What is the skills and I guess the intangibles that allow you to provide the service that you do for various customers. So far, that sounds like great. We continue to own our background IP. However, as you go through, you'll find that there are some additional comments which, once again, start to make you think harder about this. Here's the next clause. All rights, interest and title associated with company materials shall vest solely in and belong exclusively to the company. Okay, that's easy enough. Company materials, that is the customer company in this case. The customer that's put out this tender is simply saying, we continue to own our materials. And the materials in this case are very simply the things that they bring to the table. Well, as a vendor, you have no gripes with that, right? You're okay with the company owning their materials, just as you would like to own yours. What's curious, though, about this IP clause is that it goes on and on and on about company materials. Check out 15.1.2. The supplier, that's you, shall use company materials solely for the purpose of the purchase order. The supplier retains no other right, license, title, or interest in the company materials. The company shall be entitled to secure, confirm, and protect company materials. Okay, no gripes with this. It's just odd that the company putting out the tender asks the supplier for the right for the company to use its own materials. Why would the supplier have even the smallest handle on the company materials? Why should the supplier at any time actually claim the company materials? So that's a bit odd. You would think that if we, as the vendor, got to retain our IP rights, so should the company with the company materials. Also, when you then look under the glossary as to what company materials actually are, you see that there in the middle. It means all tools, machinery, equipment, blah, blah, blah. Okay, that checks out. So why would the company be so concerned about the supplier explicitly assigning what the company already owns to the company? We start to find the answer in clause 15.2. And here it is. The supplier assigns to the company all rights, including intellectual property, whether now or in the future created. No concerns. Company materials, once again, belong to the companies. 15.4, supplier acknowledges and agrees that the subject matter, that is the project materials, is the property of the company. That's also actually quite usual, because at 15.4, what you see is, in essence, that you own your background IP, but when you produce something for the company then owns what you produce for them. And again, usually people don't have a concern about that because, hey, you know, if you're getting paid by a customer and you create IP in the course of business for the customer, then yeah, the customer owns the IP you create for them, the project materials in this case, sometimes known as the foreground IP. And then comes the critical clause at 15.5. In the event that the company materials include The background IP, the supplier grants the company all rights to it. That's in essence what this says. In other words, not only does the company now own the IP that you created for the company under this project, but if you used any IP that you already had before you even took on this project, the company now owns it. The customer now has a right to it. Actually, owns it is probably the wrong word. They have a right to it. And you can see how long this paragraph is. They have absolutely every right to it. Non-exclusive, transferable, sublicensable, perpetual, irrevocable, fully paid up. That now casts all of the previous paragraphs in a completely different light. Let's go back to 15.1. That now implies that all rights, interests, and title associated with company materials, which now include your background IP, shall vest solely and belong to the company. In other words, you've just signed over your company's entire IP. Rather, the supplier has signed over their entire IP to the customer. 15.6 now also comes in a different light. You've now agreed that the rights of the company to use your IP shall arise immediately. In other words, as soon as you submit your tender documents, the company owns your background IP, period. Because your tender documents already include your background IP. Your tender documents already say what you can do and what background IP you will apply in order to service this customer. This also happens even if the customer doesn't go ahead. This clause survives even if the deliverables, services, and project materials are incomplete, or if the purchase order has expired or been terminated. You then look at paragraph 15.7. They now tell you precisely what they're going to do with all of your IP. They're now entitled to market your whole background IP, promote your background IP, supply your background IP, distribute your background IP, offer to sell, resell, or otherwise transfer your background IP to anyone. And because you signed off on the previous clauses, that now also means that you have absolutely no recourse. In fact, you've already pledged by the second half of this paragraph, you can see that highlighted here. You've now already pledged not to even think about hauling the company up for using your background IP. Once again, this casts everything in a completely different light. Look at 15.1 again. Parties agree that background IP is and shall remain the exclusive property of the party owning it. Well, that's fat consolation. You might retain the exclusive property, but because of all the other clauses, you've signed all rights away as soon as you submit your tender documents. So, Frank Rittman, this is where we need your expertise. Is my reading of all of this correct, first of all?
Well, it's certainly concerning, but there are a lot of subtle differences that go to the definitions, and I'm not quite sure it's as nefarious as you might be concerned that it is, but it is certainly something that people should be aware of and think about before they sign off on it.
All right, that's good news. So help fill in the nuances. What do we need to know? If you're one of those suppliers, if you're a vendor and you come across an IP clause as onerous as that, firstly, what should you make of it?
Well, I think in the context of this particular agreement, that IP clause alone, there's about 1,200 words in there within a larger 26-page single-space contract that's got itself about 30,000 words. And a couple of those provisions that you flashed up on had what are called defined terms, meaning they were capitalized. And in order to really understand the full intention of what those terms mean, you have to go to another provision in the contract to make sure you're clear on the definition. So all of a sudden, you're presented with a 30,000 page, 26 word, single space document that needs you to necessarily flip back and forth to even understand it. Um, First thing I notice is that, to properly read this document through, you better carve out about 2 or 3 hours
Right?
and a fresh sheet of notepaper.
Absolutely. But is it as bad, or are there some nuances we should note?
I think there are some nuances rather, and it might be worthwhile to go through them, one by one, each of those
Sure.
provisions.
Let's do that.
So, paragraph 15.1, it does say essentially in plain English, which, by the way, is what contracts should always strive to do. It's just use plain English, ordinary meanings. Basically means that what's yours is yours, you being the supplier, and it shall remain yours. But again, how is yours defined? And it's not clear in that particular paragraph. You have to go back to the definitions that appear much earlier in the contract. And background IP, in this case, is defined to mean anything that exists before the contract becomes effective or anything that's done after the contract becomes effective, but that's outside of the scope of this agreement. Whatever that stuff is, it's yours forever and always.
Mhm. Ownership, but not
Ownership.
necessarily rights, isn't it?
No, ownership would imply rights.
Yeah, but the rest of the paragraphs, you're signing your rights away. So help us read the next
Yeah, it
paragraphs.
really means what in the context of what you're doing for them. And really what it means is that what you're bringing and giving over to them, as you said at the start, is really theirs with any no fully unfettered rights of usage and ownership.
Well, that I think we can agree with, right? I was making this point earlier that if you're producing something for a client, right? Let's say you're doing like a graphic design, or you're creating fresh IP for this client's project. Most vendors and suppliers probably don't have any concerns with then handing that over. Photographers, I think, might have a slightly different view because often they want to retain the rights on the negatives. But like if you're an architect, right, and you're creating a drawing for somebody, they're paying you a fee. Sounds only right that the customer then owns the IP, doesn't it?
That's right.
Cool.
What they're paying you to create becomes theirs.
Yep, absolutely. Okay, so what are the subsequent paragraphs that you want to take us through?
Okay, well, going through the remainder of that paragraph 15.1, the next provision says that what's theirs is theirs and shall always be theirs, and that you won't question or argue with that in any way, shape, or form. And then the next provision that you showed us, 15.1.2, says that you'll only use their stuff to the extent necessary to fulfill your obligations under the contract, and that you won't do anything in any way, shape, or form with their stuff. And that it goes on to agree that you won't have any rights in their stuff, and you'll only have a right to use their stuff for as long as or as far as they allow you to use it, typically in the context of this assignment that they've given you.
Mhm.
And it finally closes out by saying that they're entitled to take steps to protect what is theirs through certain formalities, such as registering their ownership with the proper authorities.
Mhm.
That's that 15.1.
Mhm. Yeah, and once again, in general, I think we can all agree with that. The only problem is that in later paragraphs, they then say that whatever you bring to the table before this contract, they now also claim as theirs.
Well, there's some practical suggestions we can get into that. But really, what 15.2 says is that you transfer to them all right and title to anything of theirs, which is defined to include any new work that you generate pursuant to this agreement for their ownership and their use throughout the world, and you'll evidence their ownership of their work if they need you to by signing anything that might be necessary in their perspective to prove that.
Yeah, and once again, no concerns, right, for the company to lay claim to what's theirs. But then we go to 15.5, and all of a sudden, all the information, all the knowledge that you bring to the table to even service this contract is in essence what you've signed over, isn't it?
Well, I think it was 15.4 that you were showing us before. 15.5, as I read it, was something slightly different.
All right, take us through it.
Okay, so 15.4 says that after your work has been completed, you'll tell them and you'll provide to them physically anything that you might have used or created in the context of your assignment, which you again agree belongs to them. But you'll only be allowed to keep a copy of those things for as long as it's reasonably necessary for you to fulfill that assignment.
Yeah. Once again, I don't have a worry about that. If I'm creating something for a customer for payment, I have no concerns that whatever we produce as part of the project is theirs. But 15.5 doesn't say that. 15.5 says that if you use any knowledge you had prior to this project, your background IP, you've now granted a license. Take us through 15.5.
Yeah. So 15.5 in plain English says that if what you do for them includes any of your stuff or anyone else's stuff, they get to right to use that stuff forever for any purpose in any place at any time without any further payment or obligation to you whatsoever. And their use of your stuff includes their right to make entirely new stuff for the purpose of promoting or dealing with their stuff. Sorry, that's a lot of stuff.
Yeah, exactly right. And especially because, I mean, arguably, the only reason you would get hired in a tender like that is because of the background you have, right? And I mean, people generally don't create background IP out of thin air. They don't even win the contract to be able to do that. If you've got no experience, then you've got no experience to sell. They won't choose you in the tender process. So fairly obviously,
Your brain.
unconditionally, you are going to apply your background IP to creating this project, and therefore you're in essence signing over all of your background IP.
Well, you're going to bring your knowledge and your expertise to it, but that may or may not necessarily be your IP. So it gets down to the subtle nuances of practical advice that I'd give a client in that case. It may or may not be you may or may not be able to give your ideas across without surrendering your IP. But the practical answer is simply don't give them any of your background IP.
That's very hard, isn't it? I mean, if you let's say you've well, maybe like I said, you're an architect. How far does this clause then actually go? Like, are you now also signing over, previous sketches that you might have done, where you thought, hey, actually this sketch that I did 2 years ago, this might actually now work for this particular client? Or
Well,
what about the software you use? Are they implying that you must now also transfer the rights to the software to the customer?
you mean the software that's in your contract that you're using when you're preparing whatever it is you're delivering to them? No,
Yes. No?
no.
That's not counted as background IP.
No, the background IP is whatever you're putting forth to them. It's not necessarily what you're using, what's in your brain, what's in your knowledge, what's in your expertise. You can't pick my brain and take stuff out of my brain. If I do, however, give to you something that's expressed, some text that I've written before, arguably that steps into the trap.
There it is, right? Text you've used before, drawings you've created before, ideas you've had before that you've then expressed in a PowerPoint deck, for example, a Word file. Maybe you've written a book with your background IP in it. And now all of a sudden, the rights to that book is theirs.
No, only whatever you're giving over to them.
But it's
Only any
background
of your
IP.
book that you're putting in and giving to them. It doesn't go back and claw back anything that you've ever created in the history of your life that they've never seen, that hasn't been submitted over to them.
But this is the background IP. This is what you're basing maybe your knowledge on, right? Maybe you're a consultant, you've written a book, and you're now going along to teach the contents of that book.
Don't
The
give them the background
is
IP, Mark.
sorry?
You don't give them the background IP. It's that
But
simple.
you've just signed it over. It says so in 15.5.
No, but
You've
you
signed
haven't
over
given.
your background IP on a non-exclusive, transferable, sublicensable, perpetual, irrevocable, fully paid up basis.
No, you've given them the right to use your stuff, but just don't give it to them.
But that's the background IP, isn't it? I can't possibly fulfill this contract. If I've written a book, I'm a consultant, I've written a book.
Don't give
I
them
then
that book. Write something
But
new.
it's part of, it's presumably, right? Whatever you've put into that book is the knowledge and expertise, is the background IP that you then provide in the course.
No, not necessarily. It's the expression. So don't give them what you don't want them to have.
But then how can you deliver the service if you don't give them,
I,
if you don't share with
without
them that
knowing what it is that they've asked you to do, I really can't comment on that.
Gosh, this sounds like the quintessential lawyer's answer, Frank. It
Yeah, it is.
depends. It depends. Okay, but in other words, you as the vendor, you need to make sure that you have a fairly clear line as to what you share with the customer or not. And there's a good chance that you'll probably share far less than with a customer who doesn't write such onerous 1,200 word IP clauses into their contracts.
Sorry, say that again.
Yeah, so my point is that if you have a customer who's written a tender document that's a little bit more reasonable, right? As you say, not 26 pages and 30,000 words, with an IP clause that is not 1,200 words, you're probably more likely to also be just a little bit more generous with what you share with the customer. Because the assumption is the customer's not going to run off with it. When you're then confronted with a tender document like this, there's a good chance that you'll actually clamp up a little bit and say, okay, I really need to be very, very cautious about what I share here. I'm going to ring fence most of the things that I usually do so that the customer can lay no claim to it, isn't it?
That would be the best advice. Yes.
Yeah.
Ring
Because
fencing.
otherwise,
Your term.
and I think the first thing probably is that you actually need to read these clauses. 2 to 3 hours. Who's got time for that?
Yeah, that's a great point. Life is too short. I think if you were to give that contract over to an outside counsel, yeah, they'd probably bill you for 4 or 5 of their hours, and who knows? You might end up paying that lawyer more than you're getting from the customer yourself.
from,
So
from the
it
actual
becomes whether
contract.
it's cost effective or not. I think the whole overall appearance of that agreement, once you're presented with it, it does seem rather onerous. It sort of sends up a red flag right from the start. Um, it's obviously it's written from their perspective for their protection, but it's a little bit like an agreement on steroids. And as a supplier, you've got to decide where your time and interest is best. It also gets into whether you've ever heard bad things about this particular party or not. It may be that they're just erring on the side of caution, but they may as well be laying a trap that you could put your foot into and end up hanging from the bottom of a tree, hanging upside down
Yes.
from the tree.
Well, and that's exactly what PitchMark is for, isn't it? For you, as part of the community, to share some of these examples, share examples of the IP clauses you've come across, and we'll be happy to pluck it apart here without necessarily mentioning company names. But it also means that if you're one of those customers, a company that is looking for vendors, looking for suppliers, sign the PitchMark pledge so that you signal that you are more fair in your dealings with your suppliers. Frank, question is though, in a tender situation, it's not likely that you'll be able to negotiate over the tender documents, right? Because arguably all the vendors who are bidding for that project would then be needed to be given the same right. So what recourse do you actually have, apart from not taking part in the tender, if you see an IP clause like this in tender documents?
Well, I'm not sure. You could certainly flag your concern. It's generally an axiom that a contract is really just an enforceable agreement between parties. And the more you lay out what your concerns are, the more likely it might be that that particular concern won't be deemed by a court to be enforceable. So you could say, hey, I've looked at this. I have a concern that you're trying to sweep back and take ownership of everything I've ever done before. And that isn't my intention. And I'm not willing to do that. I recognize that you're asking me and paying me to do certain things for you, and I'll do that. But I don't want you going back and assuming that you've got ownership to the book that I published 3 years ago, everything that doesn't fall within the particular parameters of this assignment.
Right. So you would actually say that to the tenderer, or rather to
You
the
you
person voting?
could. The alternative is you say, "Right, my lawyer will contact you, and we'll sit down and we'll try to negotiate a win-win situation out of that." In which case, again, you're probably paying an hourly fee for a situation where people can have good faith discussions back and forth, the kind that we're having now, but even more heated or more philosophical. And at the end of the day, contracts are in the entertainment industry anyway, and this sort of situation are really a function of leverage. Um, it's written from their perspective. They're not likely to sit there and negotiate it too many times. At the end of the day, it's largely going to be a take it or leave it situation. They may or may not be willing to change that pre-printed PDF 36 page, 30,000 word contract, but they may not.
So the only choice really is to not tender.
Just be aware. The other choice again might be very cautious in what you're giving them.
Yeah.
Don't essentially give them any of your background IP if whatever the assignment is in such a way that you're able to do that. Again, they're not necessarily trawling your brain and taking all the knowledge that's already back there, unless you're giving that to them anew. it's yours to keep. So you've got to be clever enough to figure out how to fulfill that assignment without trawling back and putting into paper and submitting over to them anything that you've already done in the past.
Mm. Well, I guess people might be a bit reticent then about emailing the company that put out the tender. They might say, well, what's the point? Is there a point actually? Do you feel that PitchMark innovators should actually then go out to the company and say, hey, we'd like to take part in your tender, but not with this IP clause in it? Or
Well, I
would you
think
just let
everybody's got a
them
different
go
degree of risk tolerance, and again, the law is intended to do what's reasonable. Um, if there was a provision written in that contract that said you agree to go out and rob a bank for me, and give me all the money as part of your assignment, that wouldn't necessarily be deemed by a court to be enforceable. So again, by flagging what your concerns are, you're trying to lay out the parameters of a situation that could work against you. And heaven forbid they do try to assert ownership over the textbook that you wrote 3 years ago and say, that textbook is not ours. It's probably likely a court would say, I'm not going to enforce that.
Right. Which, of course, is some comfort. The only thing then is that you'd actually have to take the matter to court. And that's, of course, involved with all sorts of expensive lawyer fees, wink, court appearances, presumably submissions, affidavits, cost, and all the rest of it, isn't it?
Yeah, again, life might just be too short, and you might end up spending more out of your pocket to do that than you ever got from the assignment in the first place. So, at the end of the day, you have to make an assessment on what your level of risk tolerance is. Is this something that you're not concerned about, that you don't think will never come up, uh, and your nature is such that you're willing to throw caution to the wind, or are you the type that's looking for bad things to happen, and you have a reasonable concern that they're up to no good, and you don't want to put yourself at risk in any way, shape, or form? You have a rich depth of things that you think they might construe to be theirs. Don't go forward.
And the starting point, of course, is read the tender documents. Read
Absolutely.
what you're signing.
Absolutely. In this case, it would be that full 26-page, 30,000-word Megillah.
3 hours well spent. Thank you, Frank, for your counsel today, and for you, PitchMark innovators.
Happy to help, Mark.
Submit your IP clauses, the ones that you've come across in contracts. And once again, perhaps you just like Frank's view of them, or you yourself have discovered just how onerous that they are, and you'd like to share that with other members of the PitchMark community. Please drop us a note at service@pitchmark.net. Also, if you are the company on the company end, you're the one who's actually writing the tender documents, and you would like to ensure that you do the right thing by clauses 8 and 12 of the Sustainable Development Goals, then you can also get yourself a PitchMark compliance certificate, which shows that you do value the IP that your suppliers and vendors bring to you. Once again, service@pitchmark.net is the email address. We look forward to hearing from you. Thanks, Frank, and have a great day.
Thanks, Mark. Have a good day.